Good afternoon, good morning, wherever you are. Thank you all for joining us. And as folks start coming in, I'm just going to begin my introduction to this amazing attorney, Arleesha Wilson of the Law Office of Arleesha Wilson, otherwise known as the People's Esquire. Arleesha is coming from us, and she's an attorney, but I will refer to her as Arleesha. She hails from Cleveland, Ohio, and Arleesha and I met, or actually became acquainted, during a previous conference, legal conference. I saw her present and was just bowled over and asked her to come and discuss her practice area and maybe answer some questions for those who are attending. And then, of course, this is being recorded. And so if you have any questions after the fact, if you want to ask somebody to share it, come back to either one of our websites or Facebook platforms, and you'll be able to, they'll be able to visit it and watch it, and also share questions, ask questions, and we'll forward them on to Arleesha. Now, Arleesha practices in real property, real estate, specifically foreclosure defense, landlord-tenant law. And those, because of, unfortunately, the horrible circumstances that so many people, millions actually are finding themselves in, we're going to focus a little bit on, mostly on those two issues, like Maslow's hierarchy of needs, right? Shelter is really important and critical during the pandemic, and a lot of people are experiencing shelter scarcity and fear about that. But she also focuses on other really important practice areas with respect to consumers, such as bankruptcy and also general civil litigation. So with that out of the way, I think the first question that I have, Arleesha, what were you thinking when you decided to become an attorney? What were you thinking?
So honestly, it started, from when I was a little girl. I was in middle school, and there was a woman up the street from me. She had ran for judge, and she had her campaign materials plastered all over the neighborhood. It caught my attention, and I figured, if she can do that, so can I. So it was really inspiring watching her victory. I figured out, in order to be a judge, I need to be a lawyer first. And so I just embarked on that path to become a judge. And I became a probation officer after undergrad, and doing that work, really being in the context of the courtroom, right, with other lawyers and judges, that also inspired me to just make the move, go to law school. And here I am.
Wow. I mean, what you said is so important. Just having that representation in our community, seeing folks who look like us, who can actually help us navigate simple or even complex legal issues is so important. Like I told you before, and I've told a couple of folks, before COVID hit, I provided pro bono service at a family community center where I just sat at a table and waited for parents who were picking up their children to, ask me a legal question. And the community center serves children from like pre-K all the way through high school. And but I would sit there during the time where the pre-K little bitty ones, little persons, were going out for their first or their last recess of the day. And I'd sit there, and little persons would walk by. They'd stop, look. What are you?
No.
I'm a lawyer. A lawyer? are you going to be president? Because they identified being a lawyer, a Black lawyer, with being president, because this was the time when, of course, Obama was in office. And so that just made it worthwhile, whether parents had questions or not, actually just being there, showing the little people what they could do, and also who could help them, was just really, really heartwarming, and it just made it worthwhile. So I totally understand where you're coming from. So why don't we just kind of talk about the various practice areas? So talk about what practice area or areas you find most challenging, and why.
The area I find most challenging would definitely be the bankruptcy. And I think that's why there's not a lot of people who just voluntarily move toward bankruptcy, because there's a lot of nuances that you really have to be careful that you don't overlook. And it's very, difficult to understand for someone who is new to it. And so for that reason, it's difficult, right? There's a lot of paper and a lot of documents and a lot of verification and a lot that goes into that. And sometimes clients are not, they don't have that understanding of, you have to manage that, right? There's 15 documents due and they've given you 2. So that's hard, right? And just keeping up with that, it has been the challenging part, but we find systems and ways to improve every day. And so it gets better.
Okay. Yeah, I know it's, clients don't see what we do when there are piles of paper on our desk, right? They get us when we've synthesized that pile of paper to like 1 or 2 sheets, and then we spend 5 or 10 minutes before the judge, and they're like, "What?" So yeah, no, I absolutely can't. And I've never done bankruptcy. I've seen it, but you're absolutely right. I understand notice, the notice rules and so forth, doing other types of bar work. So what practice area do you think is most challenging for clients, and why?
Sure. I definitely think the real estate area is a lot more challenging for clients, specifically things like evictions and foreclosures, because not many people understand their rights when it comes to these issues, and not many people understand the procedure that's required to protect their rights or to invoke them. And so that's difficult. I wish I could just like wave a magic wand and then everybody knows.
Right? Exactly. I absolutely understand. Foreclosure, and then foreclosure has its state components and its state regulations, and then there are also the federal, rules, and the federal case law, like Garn St. Germain, I think, is one of them. And so, yeah, I can definitely understand that. Now, how did you get into foreclosure? How did that happen?
Sure. So I'll never forget, I had literally just passed the bar exam, and I announced on social media, I did it, I'm a lawyer now, guys. That was very exciting. And then I had someone who, is really near and dear to my heart come to me and say, I'm facing a foreclosure. What should I do? And I had no idea what to do because I was a new lawyer, right? And so I studied, got into the research, and I figured out what to do. So we ended up going to court, and, unfortunately we couldn't work the foreclosure out with a modification. So it was suggested that she file a bankruptcy. She called around to many different attorneys to see if she could get a bankruptcy. The lowest she found was like $900. And, of course she didn't have that, right? She was in foreclosure. Right. And so that kind of forced me to just step into the mix and file her bankruptcy, right? And so there, I figured out that that is a natural pattern, that if someone comes to me with a foreclosure, then most likely a bankruptcy is going to be an effective tool to resolve that. And so that's how I ended up with my practice areas.
Okay, great. And so you just kind of mentioned how someone, near and dear to you came to you. Describe kind of like the client experience, if you will. So how do people find you, and when they come to you, what's the first thing that they should actually anticipate and from you, and what do you need from them?
Sure. So a lot of it depends on what their particular issue is, but just generally speaking, most people find me through social media because I do a lot of digital marketing, or people find me in different directories.
Mm-hmm.
So I'm listed in a number of directories. And then I also list in a local magazine. There's a local publication called Triumph Magazine, and plenty of people find me there. That's sort of how clients find me. And once they do find me, the first thing they do is set up a consultation. So we have just a quick 15-minute phone call to discuss what their issues is and what we might be able to do to help. And then if they decide to move forward, they become a client and we work on untangling whatever the problem is they're facing.
Okay. Yeah, that untangling is really kind of interesting. So for folks who may have an issue or who may know someone who has one of these issues, how, but may not know it, how should, I guess my question is, how should people identify when they should come to you or when they should maybe try and work it out on their own?
That's a really good question, Max. And again, I think it depends on what the issue is. But for real estate issues, generally, there's always going to be some type of a court notice. So if you get some papers in the mail that says you are hereby summoned to show up in court, that's going to give me a call.
Right, exactly. Okay.
A little bit more on the proactive side, though. I think that there are, issues that lead up to that summons, right? So if you're having problems paying your mortgage, paying your rent, that is also a good time to call because maybe there's something that we can do to avoid, you getting that summons. So
exactly. Okay. Yeah, it's sometimes like I was telling you, we were talking beforehand. I do on occasion, very rare occasion, but on occasion, foreclosure defense. And it's generally because someone has inherited a home and they didn't realize that their loved one hadn't paid the mortgage. And so all of a sudden they get this notice of foreclosure. And I'm like, where did this come from? So I want to kind of dive into that a little bit. So when Ohio, Cleveland area may be different from Illinois, but I think most of the large lenders tend to be the same. So if somebody is having a very difficult time, especially now, like we said, because of COVID, and are having a problem paying their mortgage, how long do they generally have before the lender starts filing those papers?
Good question. So I have seen that it varies just depending on who the lender is. So kind of a, seller financing a small shop that has provided financing, they're going to file like right away. The bigger banks, they tend to kind of wait it out. I've seen as much as a year before a foreclosure has been filed. I think it also depends on where the property is located. If it's located in a neighborhood where the bank is clear that they can take it to the sale and get money, those foreclosures happen much quicker than a year. But I have noticed there are some neighborhoods that, they go a year without even paying a mortgage.
That's fascinating. So the neighborhood, which would kind of lend itself to the value of the home, maybe, that might be one of the issues. Yeah, and then others where the value of the home is not, as much as other neighborhoods. I guess lenders are, like you said, they'll back off a little bit. So in terms of receiving that notice, why don't you, kind of walk us through what somebody who wants to keep their home and maybe still has, they're employed, but they're living paycheck to paycheck. What does that look like in terms of fending off or defending a foreclosure?
Sure. So I think it depends on a lot of factors, but generally, I think the first place we'll look is to see if we can get a modification on the loan, to see if, maybe when they first started, the payment amount worked, but now circumstances are different. So they need a lower payment, and maybe that will help them to kind of get back on track. And so we seek out a modification to hopefully be able to resolve the foreclosure in that way.
Okay. And does Ohio or your county require a loan modification? At least the lender provide notice that might be an opportunity, or is that just something that you as an attorney know that's one of the mitigating factors that you can use?
Yeah, I think lenders do send out, the opportunity to modify. But the problem is, most clients don't understand, right? If you're a person, you have the opportunity to get a loan modification. Like,
right.
I'm in foreclosure. I don't know how that helps. So I think sometimes connecting the dots for the clients, maybe they did get that notice probably 4 months ago, but they didn't respond because they didn't understand. That's always going to be the first place where I start to see it.
Yeah, and you just mentioned something that's really important. They got the notice, but they didn't understand, and so now they're in perhaps deeper water. Maybe not, depending on how that notice was served, right? Have you ever encountered issues, or is part of maybe your strategy to also look at how they received notice?
I haven't attacked a foreclosure on the notice basis, just because most times it's right.
Right, exactly.
That have come across my desk. Most times you just can't defend there because they did the right thing.
Right. Yeah. Like I said, sometimes with probate, we'll get, the heir will inherit a property that has been foreclosed or that's in foreclosure proceedings, but they send the note to the decedent. Right. They send the notice to the decedent, and it's like, God, no, decedent that's not proper service. You actually have to send it to the heirs. We just got a really good question from Tricia. How are people handling things during this moratorium? How should somebody who is, maybe facing it or will be facing it, how should it be handled during the moratorium?
Sure. So, because of the moratorium, the first thing you have to do is file the notice that's required to invoke your rights under that moratorium. So if we're speaking, specifically to, let's say, the CDC eviction moratorium, which is set to expire on the 31st, and our fingers are crossed that renters will get additional protection. The first thing to do is file a declaration with your landlord and with the court. You want to sign it, you want to send it to your landlord, let your landlord know that you have been impacted by the pandemic, and then let the court know, hey, I've served this declaration to my landlord. And in that case, it will help you to stop the eviction. And like I said, that's only until January 31st, unless the federal government extends it longer.
Wow. Okay. And so that's the federal government's moratorium. Does Ohio, because I know Illinois, we have a moratorium that extends past the federal government's moratorium. So does Ohio have one as well, or are they strictly in line with are they aligned with the CDC and the federal government?
Yes, to my knowledge, they are aligned with the CDC and the federal government. Okay. And we're patiently waiting to just hopefully, there will be an extension of the protection.
Right, I know. It's been for certain states, especially like Illinois, it's like the first 30 days, and now it's rolling over every 30 days, and that's really kind of like a pain. It's like, why don't we just extend it completely? So speaking of landlord tenant law, what we had a conversation about this. So what are the majority of landlord eviction cases? Do they come when a person is experiencing financial difficulty, or is it generally because something is going on with the landlord and they just decided, my landlord's not treating me right, so I'm not going to pay rent?
So I think that most of the cases for me come from landlords. Most of them come from landlords. They have to evict people for non-payment of rent. But a good number of cases also come from tenants. And probably, I would say 90% of the cases that come to me when there's a tenant involved, the landlord has done something so egregious that that tenant needs representation. So, most times it involves something procedural, where, I have a case where a landlord served a 3-day notice, required this tenant to move out of the house, and called himself being nice, saying 7 days. It was a 3-day notice, but they gave them 7 days to get out of the house, or they were going to come over there and physically throw their things out. And so, of course, I saw that and said, no. Right. It's illegal.
Right. Exactly.
And so, again, there's that problem where, both landlords and tenants are not aware of the legal procedures that they have to follow to prevent illegal.
So speaking of procedures, if a landlord is acting or has done something egregious, would you, or is it advisable that a tenant stop paying rent and then contact the landlord and let them know, I'm not paying your rent until you actually address this egregious situation?
Sure. The best course of action, is not to just stop paying the rent, right? And to most people, that sort of is a logical response, right?
Yeah.
You which flooded my basement. You think I'm going to pay you to live here? No. It's logical, but the law doesn't allow that to be the proper response, right? The right thing to do is to send the landlord something in writing that says, here is the problem. Give the landlord a reasonable amount of time to fix the problem. If the problem is not fixed, you then take your rent to the courthouse and put it in what's called an escrow account.
Okay. Okay, that's interesting. That's something I didn't know, but we're different. Everything is different. Our practice areas are different. So what I heard But what I heard you say is, you have to give the landlord a reasonable amount of time. Are there any regulations or rules that, because you and I both know reasonable is very subjective, right? My basement is flooded. Reasonable was yesterday. So how do people know what reasonable is in terms of being accepted by a court or a magistrate or somebody like that?
That is a good question. And it's one of those things where, why lawyers say it depends. That's my favorite response, because it really depends, right? So it's a minor issue, like, I don't know, there's drywall kind of cracked or something. Then like 30 days, give the man some time to come and patch up the drywall, right?
Right.
But if it's something like, my furnace went out and it's January and I don't have heat, it's 25 degrees out. 30 days is not reasonable.
No.
Right? That's not reasonable.
Right.
So you would expect that, within a few days, 24 hours, 48 hours, that problem will be resolved.
Okay. And then if the landlord doesn't resolve it, let's say, okay, so now help me understand what comes first. My rent is due, but there's this problem. Should I go pay, and my landlord's not listening to me, should I go pay my rent, take my rent to the court and put it in escrow and then give notice to the landlord, or should I give notice to the landlord first and then go take my rent to the courthouse?
Yes, you give that notice first, right? Because what's important is that you've notified him and given him an opportunity to fix it. If he hasn't done that, you take your rent to the court. You can always, ask the court to compel the repairs. Step in and make sure that he is being held accountable. You can always ask the court if you can apply for the funds to fix the problem.
Okay, but you can't take that upon yourself, saying, look, my basement is flooded, I just bought a new sump pump and I'm taking that out of the rent. You're right, you can't do that. Understandable. So we talked, you kind of talked about going to court and so forth. Let me ask you this, because being attorneys of color, we understand some of the constraints that our community has, and now especially because of COVID and so many millions of people being out of work, it's kind of spread. If a client is living paycheck to paycheck, how can they afford your services? What steps can they take to maybe address some issues before they come to see you? And then when they come to see you, do you work with clients? Let's talk a little bit about helping folks who, don't even understand how to use professional services such as lawyers.
Sure. So this is something that I care deeply about, is, providing that opportunity for people to access justice. This is certainly not every single person with a legal problem, right? There are some people who feel quite comfortable coming into my office, dropping a few $1,000s for a retainer, and it's no problem. However, there's a certain set of people who just can't do that, right? They don't have a few $1,000s.
Right.
And so what I do is break it down into a more manageable payment that will be paid over the course of, however long the case is going to last. And some of my more proactive clients, they'll start paying before they need legal services, right? So I don't know if you guys have this where you are, but we have IOLTA accounts, trust accounts.
Yeah, we do. Yeah.
This money is still client's money, right? So for example, if, there's a client who, you're in debt, that you are not going to be able to get yourself out of this. You just want to file bankruptcy. You can't afford a couple $1,000s tomorrow. But I have people who have paid $100 a week, for 15 weeks. And then at the end of that 15 weeks, they have, an amount that's substantial that will cover the cost of their bankruptcy.
Right.
I really try to make sure that I make that clear to people, because most people just think, oh, it's a lawyer, I can't afford it, I'm not even going to call.
Right.
And so I try to make sure that people understand that I want to help you access justice, because it's important.
Yeah, no, it really is. And you actually brought up, you stated a good point. Most people, most people hear lawyers, they kind of equate lawyers with maybe the underside of doctors, right? It's like both of them cost a lot, but lawyer, I need help, but I can't afford it, so I'm just going to have to unfortunately go without, which is going back to our initial point about representing the community, and the visage of the community is so important, and actually letting the community know that we do work, we can work with their budgets, and also provide alternative payment structures and so forth. So I think that is really critical. So I want to kind of go back to foreclosure. So what happens? So explain a little bit more about the loan modification process. So explain a little bit more about what that looks like.
Sure. So basically, the bank is going to want to look at what are the expenses that you have coming out of your household budget, and what is the income that comes into your house. And based on that, they want to make sure that the payment is feasible. So it's kind of a process that looks at all of those details in terms of your income, and comparing them to your expenses, and understanding what's left after the expenses are paid.
Okay. So you're in foreclosure, and there's this loan modification that you want to go through that will hopefully help you keep your home. And they're looking at your finances. Are they taking, for example, your credit score into account? Because we can presume that perhaps the credit score is not where it should be if you're dealing with challenging, financial situations. Like I said, so many millions of people are right now.
Yeah. I haven't seen a credit score sort of make a modification fail. It's always the income. Something has happened with the household income, and it's just not enough income, even if there's a modification to overcome the default. So that's where I've seen the problem always come up, not necessarily with credit when it comes to a modification.
Okay, so income is the issue, and is the issue, unfortunately, for millions of people right now. And so if a loan modification is not doable, what else would you advise? Is there any other kind of relief in order to keep the house that a client would be able to avail themselves of legally?
Sure. So I typically would also recommend a Chapter 13 bankruptcy.
Okay.
Because in situations where, maybe there was a drop in income, and the client understands that they will see that income again, you can demonstrate that to the bankruptcy court, and it makes it so that their ability to keep the house is not dependent on the lender's subjective opinion of whether they can afford it. It kind of puts it in the court of the bankruptcy court decides can you afford to keep this house. And if you can demonstrate that, okay, I lost my job for 5 months, I'll be out of work the next 2, but after that my income will go up, then that will be a good enough reason where the court will decide, okay, this is something that we can allow you to work out and avoid the foreclosure.
That's important. I did not know. I didn't know that. Thank you for sharing, because I think that's a very important piece of the bankruptcy puzzle for homeowners, especially those who are in financial straits. I don't know. I don't think we discussed it, but explain the differences between Chapter 7, I believe, and Chapter 13, which you just talked about.
Yeah. Okay. So a Chapter 7 is really an instance where, the client just has too much debt to afford, right? And what's important to them is just to come from under the pressure of all of the debt. And so in that instance, they'll be able to liquidate and, discharge all of the debt, and they no longer owe it. As an alternative, there's a Chapter 13. And in a Chapter 13, that is where, they don't want to necessarily liquidate the debt. They just want to come up with a plan that will allow them to cure whatever default it is that they're having. So they still have the debt, they still have the assets, and they just have the ability to no longer be delinquent.
Okay, so if I'm understanding you right, and please correct me, because again, this is Greek to me. A chapter 7, a homeowner probably doesn't get to keep the house, but in a Chapter 13, they may get to keep the home. Am I oversimplifying that?
There's always, it depends, Max.
Right? I know.
So I would say that is true. But there are instances in a Chapter 7 where you can keep your house. Okay. So if you are not behind, if you're not delinquent in your mortgage, you can still file a Chapter 7 and continue to make those payments and discharge the other debt that you owe.
I see. Okay, great. Now, this, I have a case, and this is like a tangential related matter to the case, but it is a bankruptcy. But what about, let's say you own a condo, right? And you're in financial straits, and you can pay either the mortgage or the assessment, but you can't pay both. Can you get a discharge on the assessment?
You could, but the problem is they could foreclose based on those fees. So it would probably be a better idea to go the 13 route.
Okay.
So that you put the fees in the 13 plan so that you can cure that default.
I see. Right. I know, because I had never seen that one before. I was like, wow, that's interesting. Okay. So that's very helpful. Thank you for explaining all of that. In terms of, let's talk a little bit now just about your civil litigation practice. What are you working on? Of course, you can't breach confidentiality. We know that. But what are you working on that is kind of important to like consumers, to the community? What are you doing there?
Yes. So a lot of the litigation I do is still related to real estate. So I have cases where there was a problem with property disclosures. So in the real estate process, you're buying this new home. You are entitled to review what is called a disclosure form. It's a form that the seller is required to fill out accurately and honestly, just indicating what's, the status of your home, disclosing any problems that you have knowledge of. So I have a case where, my clients purchased this home for several hundred thousands of dollars, only to find out that there is a $75,000 problem that they have to address that was not disclosed on the disclosure form. So we now have to file a lawsuit, basically asking the court to hold this seller accountable for failing to disclose this. Because obviously if that had been disclosed, my client, would have acted differently in this.
Right. Exactly. Oh, whoa. Okay. Do you ever deal with what we call quieting title issues? And so, yeah, you're shaking your head. Yeah. So I'm going to let you explain what that is and talk a little bit about that.
Another one of my favorites. So quiet and title is basically, it's a litigation where you would sue anyone who has what's called a cloud on your title. So a cloud on your title may show up as, you had a contractor come and do some work and there's a dispute about what he is owed and he puts a mechanics lien on your property. He fails to act on that mechanics lien. And so now, you have this cloud on your title. You try to reach out to the contractor. He's like, I'm not removing it. Pay me. And you're like, I don't owe you. So you go to the court and you say, hey, court, I need to quiet the title, right? I need to remove this guy's lien, and here's why. And if you're able to show that the lien is invalid, then the court will quiet the title.
Yeah, that's something that is prevalent in Cook County, especially. And they're liens that are not valid. They're like somebody just decided, oh, this is how you put a mechanics lien on somebody's property. So I think I'll go ahead and do that. Oh my goodness. Okay, and so I guess I'm going to wrap it up in a few minutes, but I do also just want to ask. You mentioned disclosures in terms of purchasing, in terms of home purchasing, and how that can create an issue, but 9 times out of 10, if you're purchasing a home and you find an issue, you may have the means, and I'm saying that really loosely, you may have the means to afford an attorney. What if you went into a rental agreement thinking one thing, and you get into, like you just saw during the daytime, right? You just, oh, this is a beautiful, beautiful apartment. Yeah, let me sign the lease. And then you get in, and at night it's a completely different issue. Is there anything, depending on, and let's say it's a year lease, is there anything that a tenant can do under those circumstances?
So it depends, Max. That's our theme for today, right? So that is really interesting. I had a client who came to me with those circumstances, a little bit different. So she went to see the apartment, and it was like the model apartment. And then she signed the lease. Yeah, model apartment's great. This is going to be fine. They give her the keys. She gets to the place, and it's not the model apartment. It's like some other apartment with completely different aesthetics, not even clean, looks like it just needs to be painted. And she was devastated, like, oh my gosh, what do I do? And, that's one of those judgment calls where it's like, litigation is expensive, right? And if you don't have the means or the wherewithal to litigate, then that's going to make it problematic for you. You may not have a choice, right? But sometimes You can go to the landlord and say, you know what, this is really not what I expected. I need to cancel this lease and give me my money back. And sometimes people are just decent, right? And they say, okay, I'm sorry, we had a mix up, like, you know, I'll give you your money back. And that's what happened in that instance. But if he didn't give the money back, we would have had to go to the local court and ask the court to intervene and say, you know, this is a breach of contract.
Right.
Not what I signed up for. And so give me my money back.
Right, exactly. And in those cases, the client can at least ask for damages and lawyers' fees in case they have to come out of pocket for those fees. So that's actually that's at least a little helpful. But like you said, if they don't have the means to even do that, then there is a problem. And that just is, so I said I was going to let you go, but I just thought of another question. So, you know, in contract law, there's the limit law, right? For folks who buy a car and then it's a limit. Is there anything like that in landlord-tenant law?
Oh, not that I have come across. I just try to use the breach of contract laws to protect tenants because it truly is a breach of contract if you showed me something and I get something different.
Exactly. It really is. Well, I don't think we have any other questions, but this was so delightful. I just want to thank you so much for taking your valuable time. I understand how important your time is, but sharing some really critical and important information. And so this will be, like I said, it's being recorded. We are going to provide you, of course, with a recording to share on your social platforms. We will have the recording on ours. And I really do thank you again for your time. And it was great getting to know you. And let's hope that February is even better than January, right?
Yes, it was certainly great to meet you today, Max. I really appreciate you and your team for having me. It's been fun. And anytime you want to do it again in the future, just call me up.
Oh, I'm going to take you up on that. All right. Thank you so much. Have a great weekend.
You too.
Okay. Bye now. Bye, everyone.